Hello, everybody. Thank you so much for braving the wind and snow and whatever else is happening outside. And thanks especially to our three speakers who separately were in a plane hit by lightning and trekked through the snow to be here. So we're very grateful. So welcome to the Williams Farmers Campaign Finance Debate. Tonight we're discussing the motion that you see before you. This forum believes the Citizens United decision has not harmed American democracy. We're lucky to be joined by our three distinguished speakers from our nation's capital, and who combine with decades of experience working on questions related to the one that we'll tackle tonight. So before introducing our first speaker, I thought it would be wise to acknowledge that we're living in quite a tumultuous political time. Regardless of which political candidate you support, and I think I have a general sense of the room, but this election has forced many Americans, including political scientists, to reevaluate their conceptions of how politics works. We've seen candidates like Jeb Bush, well-funded in the order of millions of dollars, hundreds of millions of dollars, falter, while we've also seen the Democratic nominee do much better in terms of fundraising and success. And we've also seen Democrats outraise Republicans by an order of magnitude in the type of funding that Citizens United facilitates. So that's been another interesting thing to watch. So if nothing else, these events mean that we have a lot to discuss tonight. So the way that this is going to work is we have three speakers here, and you're probably wondering how the debate is structured. And so I'm going to introduce our first speaker, Mr. Stewart, who's going to provide us with an intimate view of some of the tough questions at the heart of Citizens United. And the reason he's particularly qualified to do that is because he helped argue Citizens United before the Supreme Court, which I think is pretty exciting. So he's going to talk a little bit about that. So you'll get to hear from somebody who knows it about as well as you can know it. And then following that, we're going to have a debate between our other two guests who fall on opposite sides of our motion here today. They're going to provide speeches outlining their position, and finally we're going to have a question and answer session. So I'll be moderating this question and answer, but if any audience questions or anybody wants to contribute, then we're more than happy to do that. So I'll lead off, and then just raise your hand and we'll call on you. And so finally, before introductions, and in the spirit of campaign finance reform, I'd like to recognize the generous sponsors who made tonight possible. So big thanks go to the lecture committee, the Williams College Political Science Department, Leadership Studies, and the Phi Beta Kappa Society. We'd also like to thank Ms. Carrie Green and Professor Justin Crow for their support in helping make this event a reality. We wouldn't be here without them. So without further ado, I'd like to introduce Mr. Stewart, and I'll give you a little bit of a background before he gets up here. So he's currently the Deputy Solicitor-General in the United States Department of Justice, a position he's held since 2008. His docket areas include antitrust, attorney's fees, bankruptcy, customs and international trade, False Claims Act, government contracts, intellectual property, patent, copyright, trademark, pollution control, securities, and tax. He's presented 73 oral arguments before the Supreme Court, which is a lot, and including the Citizens United case. From 1993 to 2008, Mr. Stewart served as an assistant to the Solicitor General. From 1991 to 1993, he was a member of the appellate staff of the Justice Department's Civil Division. And before joining DOJ, he clerked for Chief Judge Patricia Wall of the United States Court of Appeals for the District of Columbia Circuit, and to Justice Harry Blackmun in the Supreme Court. And Mr. Stewart received his JD from Yale University in 1988 and an MPhil in history from Yale in 1991. He received his AB from Princeton University in 1979. And between college and law school, he worked for 5 years as an English teacher and a cross-country and track coach at Berkeley Preparatory School in Tampa, Florida. So without further ado, I'd like to welcome you to this debate and to hearing from Mr. Stewart.
Thank you, Will, and thanks to the forum for inviting me. This is the first time I've been at Williams. I really enjoyed walking around the campus when it was snowing rather than sleeting. And coming from Washington, D.C., I'm really impressed that on a night like this, people would actually be out taking an event rather than kind of huddled in their homes, terrified that the snow was going to get them. And just so people are not starting to think as I give my presentation that this person doesn't really know what the word debate means. I want to give a disclaimer up front. I'm not going to debate the topic. I work for the Solicitor General's office. We argue cases in the Supreme Court. We advise our clients, but we steer pretty clear of evaluating Supreme Court decisions after the fact, so I'm going to try to give a recitation of what the case was about, what my experience was in the briefing and argument, and leave it to these people to debate the terms of what happened. Citizens United involved a constitutional challenge to a statute that was known as the Bipartisan Campaign Reform Act of 2002, sometimes referred to as BICRA, colloquially referred to as McCain-Feingold. I had a number of different provisions, but the provision that was at issue dealt with electioneering by corporations. And the suit was filed by a conservative nonprofit corporation known as Citizens United. For several decades, there had been a federal prohibition on corporate spending in order to influence federal elections. The law had always contained a mechanism by which corporations could establish what were known as separate segregated funds or PACs. So these would be separate legal entities that would receive funding from people associated with the corporation, specifically for the purpose of financing political communications. And the idea was corporations could spend that money if they had raised it specifically for the purpose of electioneering, but not otherwise. With respect to corporate electioneering, the big innovation of BICRA was to introduce the concept of an electioneering communication, and that was a defined term in the statute. It basically referred to a broadcast, cable, or satellite communication. So we're talking about things that were basically transmitted over the airwaves or through cable, not written communications like books or pamphlets, etc. And it was a communication that mentioned the name of an identified candidate for federal office within either 30 days of a federal primary election or 60 days of a federal general election in a place where the candidate was running. And so if you ran a communication in Pennsylvania that referred to a candidate for Senate in Texas, you wouldn't be covered. But if you were running the communication in the same area that the candidate was running, you would be covered. And essentially, the problem that Congress was responding to was that a lot of sophisticated political advertisements had been crafted that were clearly intended to influence votes in federal elections, but that didn't use what were sometimes referred to as magic words: vote for, vote against, elect, defeat. And so Congress tried to establish a bright line test for identifying communications that were very likely intended to influence the elections, Now, for individuals, the law had, since Buckley versus Vallejo in 1976, it had been accepted as a matter of constitutional law that individuals have a First Amendment right to spend as much money as they want in efforts to achieve the election or defeat of a particular federal candidate. Consequently, individuals are not subject to the kind of restrictions that were placed upon corporations by BICRA, and BICRA didn't alter any of that. As you probably know, the specific communication that was at issue, or the communications that were at issue in Citizens United, were a 90-minute film entitled Hillary the Movie and 2 short advertisements for the film. And I remember that the transcript of the film was in the joint appendix in the Supreme Court case, and I remember also watching the film in preparation for oral argument, and it was a very critical examination of Hillary Clinton's career, including her time as First Lady, including her time as Senator. That this was being run, or was proposed to be run in very early 2008. And of course, in 2008, Hillary Clinton didn't become a general election candidate for president, but she was a candidate and was running in primaries, and so BICRA potentially applied to the film because it was proposed to be run in proximity to primary elections. And my recollection of the film was that for long stretches, you would see lots of criticism of Hillary Clinton, but with no specific reference to the fact that she was running for president. And you wouldn't really have had to edit out a huge amount of the film in order for it to be perceived simply as an expose, a critical examination of a particular public servant. But every now and then, as you watch the film, you would get somebody saying words to the effect of, is this really the person we would want as our president? And I think on the whole, the electioneering focus of the movie, or at least the partial electioneering focus of the movie, was pretty clear. that there were 2 advertisements for the movie that mentioned Hillary Clinton by name, but that didn't contain the same kind of electioneering message. Citizens United proposed to make this film available for viewing on demand, but unlike what I assume to be the usual financing arrangement for an on-demand film, cable systems were not going to pay the Citizens United for the right to show the film. Citizens United was going to pay cable operators in order for them to make the film available to their customers. So in that sense, the financing was comparable to what you might think of as a political advertisement. The people who were trying to convey the message were paying for the opportunity to have it made available to the public. As you may or may not know, the federal judicial system is divided essentially into 3 courts. The district court is the trial court, then there's a court of appeals, and then there's a Supreme Court. But VICRA had a special judicial review provision that said that it established a regime in which people who wanted to challenge provisions of VICRA on the ground that they were unconstitutional could file suit in district court. A 3-judge district court would be convened, in contrast to the usual single-judge district court, and then there would be a right of direct appeal to the Supreme Court. And the significance of that was twofold. It meant a plaintiff who wanted to get her case heard by the Supreme Court in this particular context could skip a layer of federal judicial review and go right from the trial court to the Supreme Court. It also meant that whereas, for the most part, the Supreme Court can pick and choose which cases it wants to hear, the VICRA provided a right of appeal, not a right to petition for a writ of certiorari, and therefore the court's mandatory jurisdiction was triggered. The court was required to hear an appeal from a judgment. Now, for lawsuits that were filed, I think it was up to December 31st, 2006, this procedure was mandatory. Any plaintiff who wanted to challenge a provision of VICRA had to proceed in this way. After that date, it became optional, but the plaintiff had the prerogative of selecting this mechanism if it wanted, and Citizens United elected to invoke a 3-judge district court. And the primary issue before the 3-judge district court was whether the movie was really an attempt to influence elections. Now, I told you earlier that VICRA established a definition of electioneering communication that said basically, if you mention the name of a federal candidate in these particular circumstances, we'll basically have an irrebuttable presumption that your intent is to influence the election. That was the way the statute was drafted. But the Supreme Court in 2007 had recognized a constitutional limit to that provision, and the Supreme Court said, unless the government can establish that the particular communication at issue is subject to no reasonable interpretation other than as an attempt to influence the election, the statute can't constitutionally be applied to the film. And so Citizens United said, essentially, this was just an attempt to conduct a critical examination of Hillary Clinton's public career. Our intent was not to influence the election, and at least a reasonable person could be in doubt as to whether that was our intent. The 3-judge district court unanimously ruled in the favor of the Federal Election Commission. The Citizens United had filed suit against the Federal Election Commission. They didn't wait for an enforcement proceeding to be filed against them. And in essence, they said, we would like to make this film available, but given the law, we're afraid we'll be subject to criminal or civil penalties if we do, and therefore we want to sue the FEC for kind of an anticipatory ruling that the statute would be unconstitutional as applied to our film. Filed suit against in the 3-judge district court. The 3-judge district court ruled in the FEC's favor. And at that point, Citizens United took a direct appeal to the Supreme Court. There again, the primary, at least at the early stage of the Supreme Court case, the primary argument that Citizens United made was that the film was not, in fact, an attempt to influence the election. And they also made some constitutional arguments, but arguments that were distinctive to the idiosyncratic facts of their case. So, for instance, they said video on demand is different from a broadcast broadcast television advertisement because with video on demand, you only watch it if you choose to watch it. It's not like a TV ad where you're really trying to watch another program and the advertisement comes on without your will. They also said the 90-minute link makes it different. Congress, in enacting BICRA, really had in mind these shorter, more targeted electioneering appeals. And they also said that Citizens United, although it would accept some corporate contributions, was primarily financed by individuals, and that gave them a constitutional right to broadcast the film. The Supreme Court agreed to hear the appeal. In the merits brief, Citizens United made a facial constitutional challenge. That is, said that the ban on corporate electioneering was unconstitutional in all its applications, but just on a couple of pages in its brief, that really wasn't the main focus of the appeal at that stage. The case was first argued in March of 2009, and as Will said, I was assigned to do the argument in that case. And at that time, I don't think anybody perceived it to be a potential watershed event. As I say, people, for the most part, were accepting the governing legal framework under which corporate electioneering, corporate communications could be prohibited as long as they were clearly and unambiguously attempts to influence federal elections. And the question was just, was that true of Hillary the movie? And did Citizens United have some special basis for an as-applied exception to that general ban? Now, the argument took, from my standpoint, an unfortunate turn. I got questions about whether our constitutional theory would apply to books as well as to movies and broadcast advertisements. And I said, well, BICRA itself wouldn't apply to books because this particular provision is limited to broadcast, say, cable satellite communications, and books wouldn't be covered. But there is another pre-existing federal statute that applies to written materials as well. There's a more demanding standard demanding for the government, because the Supreme Court had previously interpreted the pre-existing statute to say this applies only to what's known as express advocacy. That is, communications that really use words like vote for, vote against, elect, or defeat. And so I said, under that pre-existing statute, that standard would have to be satisfied. But I said, our constitutional standard would encompass books. So if a corporation spent money on books, gave them out, they were intended to influence a federal election, the corporation, I said, could still do that as long as they used the separate segregated fund, the PAC money that was raised specifically for that purpose, but they would have no constitutional right to use their general treasury funds to try to elect or defeat a particular federal candidate. This caused great consternation in the court, and was written about later. I never come up in my own mind with a plausible constitutional basis for distinguishing a book from a movie, but there you have it. And so the case was argued in March 2009. Generally, the Supreme Court hears argument from October through April, and then there are a couple of months more when it issues decisions. And typically, all the decisions are issued, all the pending cases are resolved by the end of June. And the court will always, or almost always, will tell people in advance on which days is it going to issue opinions. But it'll never tell you in advance which cases are going to be decided on which days. So for most of the term, if you go to the court on what you know is an opinion day, if there's some particular case you're waiting for, there's still not that great a chance that it's going to come down that day. If you go, you might be pleasantly surprised or unpleasantly surprised, but it's not something you can count on. But if you go on what is scheduled to be the last opinion day of the term, then you can typically count on the idea that anything that is still outstanding is going to be decided. And so I remember going to the court the last opinion day of the term, knowing that Citizens United hadn't been decided. And they got through all the other cases, and then the Chief Justice announced that Citizens United had been held over for re-argument in September, and that the parties were instructed to file supplemental briefs on the question, basically whether a couple of prior Supreme Court decisions should be overruled, and the basic ban on corporate electioneering should be overturned. So it had suddenly become a huge deal case. And I remember sitting there and thinking to myself, I thought I had imagined what the worst case scenario would be when this morning was over, but the worst case scenario had not involved my doing any more work. And now we were being told not only had this kind of what we had thought of as a fundamental principle being called into question, but that we were going to have to write supplemental briefs about it. Now, Elena Kagan, who's now on the Supreme Court, of course, was at that time the Solicitor-General. I believe she had been confirmed about a week before I argued the case the first time around. But she was kind of established in the office by the time the order for re-argument was issued, and the case had become a huge deal case. It was the kind of case that would only be argued by the Solicitor General, and so she did the re-argument, and that was the way it would always work in our office. And she's an immensely talented lawyer. I think she's an excellent justice as well. This was literally the first case she had argued in a court. She had practiced law some, she had been a law professor, she had been dean of Harvard Law School, she had very eminent professional credentials, but she had just arrived at the Solicitor General's office and had never argued a case in court. So here we were over the summer writing a supplemental brief, helping her to prepare for her first argument in what was clearly going to be the biggest case of the term. Now, I did want to describe a couple of the strategic choices that we made in drafting the brief, and I don't think we felt that they were difficult choices, but you need to understand them to understand what we filed. The first was, as I said previously, the Supreme Court had held 35 years before that individuals have a constitutional right to make unlimited expenditures in support or in opposition to, in support of or in opposition to candidates for federal offices, and that their spending can constitutionally be constrained, and we didn't see any plausible basis for thinking that the Supreme Court was inclined to rethink that proposition. And so we accepted the idea that individuals could do this, and so the task came to be justifying the proposition that corporations could be treated differently from individuals for this purpose. The second proposition that was also established in Buckley versus Vallejo that we, again, didn't think that the court would ever rethink and that we didn't encourage it to rethink is the Supreme Court has said just about the only and probably the only accepted justification for campaign finance restrictions is the prevention of actual or apparent corruption. That is, the idea that office holders will become beholden to their financial benefactors and will tend to treat their interests more favorably when they pass or vote against legislation. And the Supreme Court specifically has said it's not a justification for campaign finance regulation that you want to equalize the voices of rich and poor interests. That is, you can't say constitutionally the Supreme Court has held that billionaires should be limited in the amount they can spend on elections because most people don't have that kind of money, and millionaires shouldn't have more influence on the political process than anybody else. The Supreme Court has basically said if you're lucky enough or smart enough to have that kind of money and you want to spend it on politics, that's your First Amendment right, and the fact that it will give you greater practical influence than somebody who's not comparably wealthy is not something that the Constitution allows the Congress to do anything about. And we accepted that principle. We didn't argue that the ban on corporate electioneering should be defended on an equalization rationale. The basic argument, which had a fair amount of grounding in the legislative record, was that members of Congress would tend to look more favorably on entities that had run advertisements in their support, would tend to look less favorably on entities that had either refused to do so or had run advertisements in support of their opponents. And we said Congress can legitimately attempt to combat that form of either actual corruption or people believing that the legislators are corrupt by limiting the extent to which corporations can engage in these communications. And the case was argued in September. I don't remember the exact date of the decision, but it was probably around December or January, and we lost the case 5-4. And I'd say the court rejected Citizens United's narrower arguments. It said it makes no difference that this is video on demand, it makes no difference that this is 90 minutes, and just ruled on the broader theory that corporations, be they nonprofit corporations or business corporations, have a First Amendment right to spend money in support of or in opposition to federal candidates. The court also rejected Citizens United's argument that the movie was not in fact an attempt to influence the election. And I'd say the court's decision rested on three principal pillars or rationales. The first was that the court found in the constitutional text and history no relevant difference between individuals and corporations. It relied on the accepted principle that individuals could have done this without interference from Congress, and didn't find anything in the text of the First Amendment or anything in the history from the founding era that would suggest that corporations should have less extensive First Amendment rights. The second thing is that I think the court, although the court's opinion to me is not entirely clear on this point, the court seemed to have both a narrower view of what constitutes corruption and a more skeptical view of the likelihood that members of Congress would be unduly influenced by independent expenditures in their support. The court said specifically that ingratiation and access are not corruption, and therefore if the individual legislators give meetings or are in a very general way favorably disposed to people who have run ads in their support, that's part of the political process and not a form of corruption that Congress can attempt to combat, at least in this way. And then the third thing was that the court emphasized that nobody disputed the right of media corporations to run news coverage that mentions federal candidates, editorials that take a position on the proper outcome of federal elections. There had always been an exemption in the statute for media corporations so that nobody under current law worried that those types of broadcasts would actually be prohibited, but the court said if we accept your constitutional theory, then newspapers and television stations, if they are organized in a corporate form, could likewise be forbidden to take positions on the proper outcome of federal elections. The favorable aspect of the court's opinion was that the court upheld the statute's disclosure requirements. BICRA had required both that the communication itself should identify what entity has sponsored it so that people have a general idea of who can be held accountable for its content, and the entity that runs the communication is also required to file more comprehensive forms with the FEC that make clear what people have contributed to the film so that people can understand not only that it's Citizens United that's run the Hillary the movie, but can, if they care enough about it, can look at the FEC filings and can see who were the people who contributed to Citizens United. And it kind of in prelude to the debate, I'd just like to offer a couple of thoughts in summary. The first point I'd emphasize, and I think I've alluded to this idea already, is Citizens United dealt with what is really just one piece of a much more extensive constellation of issues involving the general subject of money in politics. I think some people have a tendency to equate Citizens United with the larger problem, but there were important aspects of that, of the question of money in politics, that would be regulated in more or less the same way, regardless of how Citizens United had come out. For instance, the proposition that individuals have a right to make unlimited campaign-related expenditures, that we treated as bedrock. If the government had won Citizens United, individuals would have continued to have that right, and obviously there are a lot of wealthy people who can bring substantial resources to bear on election-related funding. And some other pieces of this same puzzle, the court didn't question its prior decisions that had drawn pretty sharp distinctions between expenditure limits and contribution limits. And so while Congress can't prevent corporations from running their own advertisements that endorse particular electoral outcomes, corporations can't give money directly to federal candidates. Individuals are pretty sharply limited in the amounts that they can give to federal candidates. And so that piece of the campaign finance puzzle, the rules governing direct transfers of money to candidates and also to political parties, was not affected by Citizens United. And the court upheld the statute's disclosure requirements. And so I think it reaffirmed the principle that even in areas where Congress can't prohibit a particular form of speech, it can require the speaker to furnish the public with information that will allow the public to better evaluate where the speech is coming from and allow the public to see down the road whether there seems to be any link between the source of favorable advertisements and the legislator's behavior once he or she is in office. The second thing I emphasize is that the policy issue that is the focus of the debate tonight is distinct from the constitutional issue that was before the Supreme Court. The constitutional issue was, does the First Amendment prohibit Congress from enacting this restriction if it believes that that's wise public policy? But the policy issue is just, is it a good idea? And in particular, what has happened, the question is framed by the debate, what has happened since Citizens United has decided, what's happened on the ground that would cause people to believe either this was a good idea or a bad idea. And those, part of the reason, the main reason that I'm here to debate the resolution is that I work for an office that doesn't break the Supreme Court decisions after the fact. But part of it is that in judging whether Citizens United has harmed our democracy, you're really looking at least at empirical questions. Is public policy being made in a different way in light of Citizens United than it would be made otherwise? And you're also making value judgments to what relative priority do you assign to having the most effusive, robust public debate versus the priority you assign to reducing to the bare minimum the opportunities for federal legislators to be corrupted. And those, in both the pragmatic judgment, what's happened since GU, and the value judgment, which of those two things do you attach greater weight to? My expertise as a lawyer doesn't really give me any particular qualification to speak. The last thing I did want to tell the audience here, just because I thought it was interesting at the time it happened, even though it has nothing to do with the resolution and not much to do with the case, is I go to all the Washington Capitals hockey games, and several years ago I got new seats and wound up sitting next to a father and his adult sons, and we got along very well. And then all of a sudden, out of the blue, like 2 or 3 days after I argued Citizens United the first time, the son came up to me at the next game and kind of smiled and said, "Well, my dad saw you at the argument on Tuesday or Wednesday or whenever it was." And I wondered, why is his dad at the oral argument? Well, it turns out his dad is on the board of directors at Citizens United. And so we agree on the Caps, and we've gotten along very well since then. And I do want to thank Will and the forum for inviting me. It's really a pleasure to see all of you here tonight.
Thank you so much for coming here and speaking. That was really, really interesting to listen to. So what I'm going to do is I'm just going to get out of the way after I introduce these guys, and they're going to present their cases in front of you, and then we'll have some back and forth debate, if that sounds good. I guess it doesn't matter if that sounds good to you, because that's what we're going to do. So I hope you like that. So our first speaker, Mr. Ilya Schapiro, is going to be arguing in favor of the motion. Mr. Schapiro is currently a senior fellow in constitutional studies at the Cato Institute, and he's also editor-in-chief of the Cato Supreme Court Review. Before joining Cato, he was a special assistant or advisor to the multinational force from Iraq on rule of law issues and practiced the patent box and clear colleague. He's the co-author of Religious Liberties for Corporations, Hobby Lobby, the Affordable Care Act, and the Constitution, and numerous other publications. Mr. Schapiro has testified before Congress, state legislatures, and is coordinator of Cato's amicus brief program, filed more than 200 friend of the court briefs in the Supreme Court. He lectures regularly on behalf of the Federalist Society, is a member of the Legal Studies Institute's Board of Visitors, the Fund for American Studies, was an inaugural Washington Fellow at the National Review Institute, and a Lincoln Fellow at the Claremont Institute, and has been an adjunct professor at the Washington University Law School. And before entering private practice, Mr. Schapiro clerked for Judge Grady Jolly at the U.S. Court of Appeals, the Fifth Circuit. He holds an A.B. from Princeton, an MSc from the London School of Economics, and a J.D. from the University of Chicago Law School. And maybe a round of applause for Mr. Schapiro. And our second speaker, Mr. Daniel Weiner, is going to argue against our motion. Mr. Weiner currently serves as senior counsel for the Brennan Center's Democracy Program, where his work focuses on money and politics. Prior to joining the Brennan Center, Mr. Weiner served as senior counsel to Commissioner I Weiner at the Federal Election Commission, including during her term as chair of the commission in 2013. In this role, Mr. Weiner assisted the commissioner with her duties in managing the agency and advised her on a broad array of issues under the First Amendment, the Federal Election Campaign Act, and the Administration Procedure Act. Before his service at the FEC, Mr. Weiner is an associate in the Washington, D.C. office of Jenner & Block. At Jenner, he counsels a wide variety of clients and litigated cases at federal levels, including as a member of the firm's election law and redistricting practice group. He maintained an active pro bono practice focused particularly on LGBT rights. He received his J.D. degree cum laude. Not familiar with Latin honors.
Thank you, Lottie.
I don't think I'll be receiving any Latin honors. From Harvard Law School in 2005, he was an executive editor for the Harvard Civil Rights, Civil Liberties Law Review, and co-articles editor for the Harvard Journal of Law and Gender. So without further ado, I came here to hear them and not me, so I'd like to introduce Mr. Schapiro to argue in favor of our motion.
It's great to be here. When Will first asked me to come here, I'm like, oh, you're trying to do the same sort of thing that Amherst tried to start up a few years ago. I did one of their political union debates. And he said, well, sort of. Well, I mean, I just hope that your mascot isn't discovered to be some politically incorrect in some way. You know, that whole Lord Jeff thing. That's my you know, pro Williams, anti-Amherst. Try to appeal to your audience. Well, look, are any of you fans of Stephen Colbert or Jon Stewart? No. I like the former, not the latter, because I think Stewart is all about his political agenda, and Colbert is probably, you know, while having similar, identical, effectively, political views, is probably more of a showman. But maybe I'm biased because Colbert's had me on his show and Stewart did not. But this dynamic duo, more than any pundits, have shown the unworkability, instability, and farcical nature of our campaign finance regime. Now, my diagnosis of the underlying problems, and so my prescriptions for future reform and views on Citizens United are different than theirs, but I agree that our current system leads to perverse and often comical results. And I hold that Citizens United was correctly decided for the very simple reason that political speech should be free regardless of the nature of the speaker, that people don't lose their rights when they get together, whether in unions or nonprofit advocacy groups or businesses or social clubs or any other way. Indeed, this whole case and the way that you can read the resolution boils down to the question of whether you think the government should control who speaks, for how much, on what subjects, and when. Giving the government that kind of control over speech, over core political speech, seems dangerous. And so any ruling that goes against it is a victory for democracy, plain and simple. That's my statement about the resolution. And before I go further, let me say, some of you probably are saying, oh, but you said speech. Money isn't speech. Well, yeah, I mean, but money, you know, money's not abortions, money's not guns, money's not typewriters and laptops and bullhorns. But if you ban spending money on any of those things, you run into a constitutional problem. Okay? restricting or regulating something that facilitates the exercise of a constitutional right is regulating or restricting that right. So let's dispose of that cute trope about money not being speech. And again, this is not, Citizens United was not kind of the be-all and end-all, alpha and omega of all of the campaign finance regime. It had nothing to do with who can contribute to political candidates or parties and how much they can contribute. All it has to do with is independent speakers. Can people join together, pool their money, regardless of whether that money comes from, I mean, to speak independently about politics? And you know, Malcolm talked about this convoluted law, the electioneering versus non-electioneering issue advocacy, which is just so much legalese that that's why that distinction sort of fell apart. But fundamentally, this is about, can people come together to speak independently about politics? And that's why a decision that moves in that direction helps our democracy. But the ruling does create the odd situation whereby independent political speech is relatively unrestricted, while candidates and parties are heavily restricted and regulated. If you look at who gained from Citizens United, it's nonprofits, advocacy groups, and independent speakers like I own Cato Institute, or the Sierra Club, or the ACLU, or the NRA, or Planned Parenthood, small business associations or trade groups. It's not your Fortune 500 companies. They don't spend on political electioneering because it's not cost effective. They lobby, which has its own set of regulations and restrictions, and Citizens United had nothing to do with that, and they're rightly heavily restricted and regulated because there is where the corruption can really happen. And moreover, for-profit corporations, be they whichever ones you think are good or bad, you know, Exxon, Microsoft, Halliburton, Google, whichever ones you might like or don't like, they don't want to alienate half their client base, right? So that's why they don't spend on electioneering up front. As Michael Jordan once said when asked why he doesn't get more involved in politics, he said Republicans buy speakers too. And so, you know, Citizens United is not about big for-profit corporations spending money on politics. It's about trade associations and advocacy groups and the various organizations that I listed. The losers, meanwhile, from the decision are political parties and candidates. That might sound strange, and I mean relatively speaking, because again, Citizens United said nothing about political parties and candidates and their rights and their contributors and so forth. But relatively speaking, by freeing up the independent political actors, the regulated candidates, parties, campaigns are at a disadvantage. They now have less money, relatively speaking, and less control over their message. That's not necessarily a bad thing, because parties and candidates aren't privileged under the Constitution in terms of First Amendment protection for political speech. But it does create a weird dynamic. And so we have this system with strict limits on candidate contributions, but not expenditures. I'll go into this a little bit. And no limits on, effectively, on independent groups' contributions and expenditures. That's not a stable system. I think at the end of the day, we have to, you know, Citizens United is a half-loaf for democracy. We have to go further. We have to correct this imbalance by liberalizing the campaign finance regime and getting rid of limits altogether on contributions to candidates, individual contributions, not corporate ones. And then maybe have disclosures for those who donate a certain high amount. Because then the big boys who want to play in the political market will have to put their reputations on the line, but not the average person who just donates a relatively small amount of money and then is possibly exposed to boycotts and vigilantes. But let me step back. Citizens United itself is both less and more important than you might think to the discussion of American democracy or money in politics. It's more important because beyond whatever effort it's had on money in politics, which is really more in terms of shifting it around than in terms of bringing more money into the system than was otherwise, you know, naturally growing each election cycle. But it's revealed the system's instability and unworkability. And it's less important because it doesn't stand for half of what people think it does, whether they agree or disagree with it. Take, for example, President Obama's famous statement at the 2010 State of the Union. He said that Citizens United, quote, reversed a century of law that I believe will open the floodgates of special interests including foreign corporations, to spend without limit in our elections. In that one short half sentence, the former constitutional law professor from my alma mater, University of Chicago, made 4 errors of law. It's quite remarkable. Citizens United did not overturn a century of law, but 20 years. Now, Obama was referring to the Tillman Act of 1907, which prohibited corporate contributions to candidates. That was untouched, not an issue in Citizens United. What was overturned was a 1990 case called Austin versus Michigan Chamber of Commerce, which for the first and only time, it was an aberration, the only time, it allowed a regulation of political speech based on something other than the appearance thereof, as Malcolm described. And by the way, the idea of corporate personhood is not controversial. Citizens United didn't create that as well. It's been around for more than a century. And when you think about it, corporations are a legal fiction that allow us to pursue commerce in various ways. And if they didn't have rights to allow the people that make up the corporation to pursue their constitutional rights, then individuals, natural persons, would be hurt. So, Fourth Amendment say, if the police raided the offices of IBM and took all their computers, if the IBM didn't have any rights, then they could do that. If there's a problem with that. Or the mayor of New York, if he wanted to relocate his office to Rockefeller Center, just decided to take that without paying just compensation because the corporation doesn't have Fifth Amendment rights. That would be problematic. So again, the corporations have rights in order to facilitate lawsuits, sell shares, otherwise engage in commerce, and to protect the exercise of rights by the underlying individuals. But again, Citizens United broke new ground here, and indeed there were only 2 votes in Citizens United against the proposition that corporations have First Amendment rights. Now, opening the floodgates to special interests depends how you define those terms. As I said, there's been no huge increase in spending by for-profit corporations, though there has been by unions. And there are now people running super PACs who would otherwise be bundlers, kind of collecting donations to candidates. So again, it's changed how the money is spent, but it hasn't necessarily increased the money. Perhaps there's somewhat more money by individual billionaires, whether George Soros on the left or Sheldon Adelson on the right, Tom Steyer on the left, the Koch brothers on the right, these really rich folks. But they didn't need Citizens United to act before. They had other, they have a big pot of money. Citizens United said nothing about an individual spending their money independently. The rights of foreigners, right? Foreign corporations, unlimited. Well, no. The rights of foreigners was and is restricted, and Citizens United had nothing to do with it. And indeed, 2 years after Citizens United, the court summarily affirmed the restriction on anyone who doesn't at least have a green card from participating in, from donating to candidates and campaigns. I just became a citizen 2 years ago, by the way. Like most immigrants, I do a job that native-born Americans won't, and that's defending the Constitution.
That one always works really well for you.
It does, it does. My wife rolls her eyes. She's heard it many times. She's only heard it once before. So. And finally, the idea that spending on elections now has no limits. Well, whether that's a good thing or a bad thing, it's not true. It's more or less true for independent speech, but it's not for candidates and parties, again, whose spending was not an issue at Citizens United, nor for donors to candidates and parties. So these are some very basic points that even people who agree with Citizens United misapprehend. Okay? All that Citizens United did, and kind of its follow-on case called SpeechNow.org at the DC Circuit, was to allow people to get together to pool their money. Like if you and 9 other friends have $100 each, you can now spend that in exactly the same way that one person having $1,000 could spend it the whole time. Okay? That's a pretty big deal. Why should you be restricted from pooling your money with your friends to speak about politics? Again, nothing to do with contributing to candidates. Now, we hear a lot about super PACs, and this is the real bogeyman that's created by Citizens United that really harms our democracy. And this is what generated the big Comedy Central satire. I don't know if you were watching the last presidential election. I guess some of you were in middle school or what have you. But Stephen Colbert had this super PAC called Americans for a Better Tomorrow. But then he decided to run for President of the United States of South Carolina. So he had to give up control of his super PAC because there are rules against coordinating between a candidate or a party and a super PAC. So who did he give control of it to? Well, his business associate, John Stewart. And they got together and they held hands, and you can see this cartoon, like green dollar signs flowing from Colbert to Stewart, and Stewart says, "I have the power," right? Hilarious. Because it's farcical, right? Because they know Stewart knows what his buddy Stephen's strategy is for running for President of the United States of South Carolina. Moreover, Stephen has his show. He can just say, "Here is my strategy," and Stewart, without officially talking to him or coordinating, can follow that. But the reason for all of these nonsensical, ridiculous, funny regulations is that the law restricts donations to candidates, but not to independent groups. So again, we have this imbalance. And that imbalance wasn't created by Citizens United. It was created fundamentally, what the original sin of our campaign finance regime is a case called Buckley versus Vallejo in 1976, which was the source of our modern campaign finance regime, which ruled upon the Federal Election Campaign Act of 1976, a post-Watergate anti-corruption reform that did several things. It restricted donations to candidates, it restricted spending by candidates, and provided public funding, at least for presidential elections. What the court did with that is to split the baby. It rewrote the law to tweak part of it, knock down the limit on candidate spending, because that's a First Amendment violation. The candidate's not corrupting anybody by spending money. And so it created a system whereby candidates face an unlimited demand for campaign funds, but a tapered supply. That is, they have to get it in small increments. And that's why politicians spend so much time dialing for dollars and otherwise fundraising. Now, some people might think that's a good thing, that keeps them that's that many hours away from like wreaking havoc with government and the economy. But nevertheless, these types of campaign finance regulations have gradually pushed the flow of money away from candidates, or made it harder for them to raise money, and towards advocacy groups that are unaccountable to the public. So this whole post-Watergate accountability, anti-corruption rationale, the Supreme Court in Buckley, by making this constitutional distinction that you can restrict contributions but not expenditures, the Supreme Court created this motley regime. Campaign regulation, that is trying to manage the flow of political speech, is a graveyard of well-intentioned ideas, even before the Supreme Court started messing with it. Reformist ideals go awry in practice because political money is a moving target that, like water, has to go somewhere. If not to candidates, then to parties. If not to parties, then to political action committees or super PACs or advocacy groups or what have you. Because what government does matters, and people want to affect issues that they care about. And so if you think that money in politics itself is a problem, and that's an issue far broader than Citizens United, then the solution isn't to try to reduce the money. That's a Sisyphean task. It's impossible. But it's to reduce the scope of political activity that the money affects. I agree that we should reduce the scope of money in politics. How? By reducing the politics. Reduce the size and scope of government, at least in Washington, and I guarantee you will reduce the amount of money chasing those election campaigns. And even if you're concerned about the money spent on electioneering, although Americans are spending more money this week and this month on Halloween candy than they do on the election, the problem is not, again, the big corporate players. So get kind of out of your minds. It's hard because it's been so demagogue, but it's not, your big for-profit corporations. Think about your, whatever your favorite one, your least favorite one. They are not the ones making ads either about candidates or about gun control or abortion or debt. They're not involved in that sort of thing. Okay. The organizations that are benefiting, as I said, are Citizens United itself, a political advocacy group, or your National Federation of Independent Business, or your National Rifle Association, or Planned Parenthood, or whatever your favorite group might be. they can't compete with the big boys on K Street generally. I mean, they have serious money that they established ones in DC, but they're nothing like the trade organizations and the industrial groups. But they sure as hell are going to make the public aware of Congress's shenanigans. So, even if we accept leveling the playing field as a valid reason for regulating political speech, Citizens United freeing up of associational speech does level that playing field. So the advocacy groups, the nonprofits, etc., now have relatively more speech relative to, or they do speak more relative to the for-profit businesses. And so we're left with a system that's unbalanced, unstable, unworkable, and we haven't seen the last of campaign finance cases at the court or attempts at legislative reform. I would wager that in the next decade, we'll see enough incumbents, centrists, we're not talking like the radicals who are dyed in the wool, money in politics, blah, 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 I don't want to hear any of your reasons. Coming from incumbents who feel threatened that they've lost control of their own messages. At that point, Stephen Colbert would have to focus on other things, but I'm confident that he'll find something else to ridicule, and our American democracy will be the better for it. Thank you.
Well, that is a tough act to follow, both two tough acts to follow. I'm thrilled to be here. Thank you so much to the Williams Forum for organizing this event. I think it's great. I was trying to think of a good opening joke, and then I thought, well, I went to Brown, which is a joke, so maybe I'll do that. I can't really compare. You guys are so serious and intense here. It's intimidating.
They have provided you a safe space back there.
Oh, they have? Good. I'm going to need to go there and start my thumb. But not right now. So, Citizens United. Surprisingly, I don't disagree with everything Ilya said. But I do disagree on a meta level. That's why you're having me. For me, Citizens United is significant less for the specific holding of the case than because it exemplifies larger jurisprudential trends that we've seen intensify. Ilya is right that a lot of this didn't come from Citizens United. It came to some degree from Buckley, Viva Leo, an earlier case, and from other cases in the court's history. But Citizens United doubled down on these ideas, and as part of a series of decisions that have, I think, radically changed our campaign finance jurisprudence. And the two key ideas, which Malcolm and Ilya summarized, are one, that so-called independent spending doesn't corrupt and therefore can't be regulated, and two, that any effort whatsoever to level the playing field is verboten and completely inappropriate, down to just, and this was a subsequent case, but it built on Citizens United, if the government just wants to, in a public financing system, give a candidate facing massive outside spending a higher subsidy so that they can get their message out and so public financing can be effective, that is not allowed under the jurisprudence that Citizens United exemplifies. So what are the negative consequences for our society and for our democracy, for Citizens United? Well, I think there are at least 6. One, that the court probably was aware that it would happen, and 5, that it had no idea whatsoever, but it blended into it anyway. So let's start with the one that it was aware of. Now, Citizens United has, as you all know, allowed a handful of billionaires to pour unprecedented amounts of money into our political system. Now, wait, you're going to say, but they could do that anyway. Buckley let them do that anyway. But here's the thing, federal law, after Buckley, required them to put their names on those ads. So the ad would say not brought to you by For Americans for Apple Pie or Americans for a Stronger America. It would say brought to you by George Soros or brought to you by Charles and David Koch. And surprise, surprise, they didn't do it then. But now, after Citizens United, because people can band together, they can give money to essentially an organization that has whatever anodyne name is possible, and they can throw the money into our system that way. And I think that is a big change. In 2014, and this was not the case in prior election cycles, The top 100 donors to super PACs gave almost as much as all 4.75 million small donors combined. And what this has actually done is it has blunted a trend that we saw in 2004 when many of you were probably in utero. But, you know, Howard Dean, a guy named Howard Dean, remember sort of screaming a little bit? That's
Nightmares when they were in elementary
I know, it gave me nightmares too. But Howard Dean was the first candidate who raised a lot of money on the internet. And he was supposedly going to herald this new age of, you know, small donor democracy, you know, facilitated by technology. And we thought that would happen. In fact, however, because of Citizens United, the ratio of small donors in our elections has fallen every year since 2007. And the first cycle after Citizens, since 2010, excuse me. So, what does this all mean? And people like to talk about the presidency. And I understand, and there are consequences for the presidential race. We have presidential primaries now where one billionaire mega donor basically sponsors a particular candidate like a racehorse. So they call it with Sheldon Adelson the Sheldon primary. It's because they all go to Las Vegas, they all kiss up to him on his two issues that he cares about, Israel and banning online gambling so it won't compete with his casinos, and they all kowtow and then he backs them. So that's on the presidential level. Now I realize the people who won the Sheldon primary didn't win the presidential primary this year. But to really understand the effects of Citizens United, you also need to look below the presidential level. And actually, I would argue that that is where you are seeing the most acute effects of Citizens United, is at the congressional level and even more frankly at the state and local level. In Utah, for instance, Attorney General Don Swallow funneled funneled actually very little, $400,000 that he was allowed to raise to dark money groups, to outside groups, which were, the money came from payday lenders, and he offered those payday lenders light regulation in exchange. In Wisconsin, you have outside groups sponsored by a mining company that spent $700,000 to unseat a state senator, and they got a change in the permitting rules that allowed them to build a taconite mine. And you know that change was? That was by one vote. And I could go on. Power suppliers in Arizona using their money to get people off the Public Utilities Board. Charter school organizations in LA. This is where Citizens United is affecting our democracy most. It's not necessarily affecting it at the presidential level, is affecting it, I think, most acutely at the state and local level, and then to some degree the congressional level. So that is a change that the court probably anticipated. Justice Kennedy, the largest voices of our economy are muzzled, yada, 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 yada. They knew that this was going to happen, and it has happened. But then we get to the point that there are at least 5 other consequences of Citizens United that the court had no idea would be reality. Now, first, it has shattered contribution limits. Now, why has it shattered contribution limits, which the court said that it wasn't going to touch? It's because supposedly the spending is independent. We have always distinguished between independent campaign spending and so-called coordinated campaign spending, which is tantamount to a contribution. But the reality is the vast majority of outside spending that Citizens United enabled is coordinated. Scott Walker, did you read the revelations in The Guardian? Scott Walker the governor of Wisconsin, was raising $1 million checks from outside groups that were going to, quote, provide the correct messaging. He was raising this money for them, funneling it into them, and that helped him win his recall race. And this is happening constantly at the federal level. Very little of this money that Citizens United enabled is actually spent independently. And in fact, in the presidential primary, you saw most of the candidates basically had a pet super PAC. It was set up by their former staff. It was, coordinated messaging, and some John Kasich even appeared in the PAC's ads before he declared his candidacy, and that's where all this outside money is going to. It is not going to little bands of platoons of citizens making their independent speech. It's going to groups that are basically bought and sold by the candidates. So it has destroyed contribution limits, notwithstanding what the court said. Whether they were being disingenuous or they just didn't realize that would happen, I can't tell you because I'm not inside their minds. And we see that, vast percentages of the people who give to these outside groups also give to the candidates. So it's very clearly a conduit of contributions. So that's one unintended consequence of Citizens United. Another unintended consequence of Citizens United is an explosion in secret money. The court said it loved disclosure. Disclosure is great. It's interesting to read Citizens United because many people who do what I do thought that disclosure was kind of the next pillar that was going to fall, that the court really was going to take out disclosure. In fact, many libertarians and people on the right hate disclosure rules, and they think they should be unconstitutional. Instead, the court went gangbusters on disclosure. They love disclosure. Transparency is great, and in some sense what they're actually doing, I think, is positing disclosure as kind of an alternative to other rules. The reality, though, is at least $700 billion of the money that has been, $700 million of the money that has been spent, thanks to Citizens United, has not been disclosed. It comes from groups that don't disclose their donors, and then again have names like Americans for Apple Pie or Americans for Good Government or whatever. We have no idea where that money is coming from. And again, and I'm going to sound like a broken record on this, that trend is even more acute at the state level. In the state of Arizona, just to give you one example, secret money has gone up by almost 300% from where it was before Citizens United to where it was after. And this matters. If you are thinking about, charter schools, for instance, and someone is running an ad about charter schools, it matters whether that ad is coming from Michael Bloomberg out in New York in his pet charter school thing, or your local parent-teacher association. It matters whether an ad is coming from a veterans group versus a big defense contractor, but people are not getting that information right now. And the lack of transparency has had, I think, particularly negative consequences for shareholders and consumers. And this is really, in some sense, the third unintended consequence. The court in Citizens United waxes prosaic about shareholder democracy. If the shareholders don't like what the corporation is doing, they can blah, 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 blah. The reality is, A, the shareholders don't know what the corporations are doing, because in fact, big corporations largely funnel their spending into dark money groups. So George Soros and the Koch brothers and Sheldon Adelson, they give to super PACs. Big companies, and this has happened because of mistakes in filings where this pops up. We saw Aetna gave $7 million to some nonprofit. It's definitely happening. Big corporations give it to dark money groups so that they don't have to suffer that transparency. And that basically means that shareholder democracy, which was supposed to be a check if you don't want your money as a shareholder being spent on this stuff, there's no way you can find out. And so actually, a lot of the money being spent pursuant to Citizens United is not people spending their own money, it's people spending other people's money. High-level corporate managers spending money that belongs to shareholders. And that also hurts consumers. Because, I actually think boycotts have an honorable tradition in this country. I realize they make people uncomfortable, but if you do not want to do business with a company that supports things that don't align with your values, that is a fundamental American right. And if a large corporation, there was a scandal in Minnesota, I happen to be married to a guy, I'm very profoundly pro-marriage equality, I also love to shop at Target. Target was funneling hundreds of thousands of dollars to a candidate in Minnesota who was viciously anti-gay. And they wanted to do it because he was, in favor of their business interests or something. I would not have wanted my money at Target going to support this guy. And the only reason there's that sort of accountability is you have disclosure. And Citizens United, again, a lot of the money that has been spent as a result of Citizens United is not disclosed. And in addition to that, one of the most pernicious effects of Citizens United is also that corporate employees now are getting coerced into participating in corporate spending. When corporations were banned from spending money, they were obviously banned from forcing their employees to contribute, to be part of their political activities. One of the strangest and I think most troubling things that has happened since Citizens United is a growing number of corporations basically saying it's a part of an employee's job to appear in an ad. There's a mine owner in West Virginia who forced his employees to appear at a Romney rally. This is also a consequence of Citizens United. So I'm almost done. But foreign money. I think we're at consequence number 4 of the unintended consequences, 5 of the overall consequences. So foreign money. Ilya says there is no foreign money. The court said, well, we're not doing anything about it, and they issued a decision. The reality, though, is that the prohibition that they upheld literally just applies to foreign nationals. It does not apply to the domestic subsidiaries of foreign corporations, and it certainly doesn't apply to large corporations that have large foreign institutional investors. And in fact, that's about 10% of the S&P 500. So to say that foreign influenced corporations are not now able to spend large sums of money in our elections is just factually incorrect. And Citizens United allowed that to happen. And then finally, I would just say that Citizens United undermined public trust. The court said in Citizens United, citizens will not lose faith in our democracy by this decision, which I think must be very obvious from First Street, what ordinary people will or will not lose faith in our democracy about, but they said it, and that has absolutely not happened. Obviously, it's one of the most unpopular decisions in the court's history. A recent poll showed that 80% of Americans disapprove of it, including overwhelming majorities of Democrats and Republicans. A recent Gallup survey showed that 3/4 of Americans believe the government is corrupt. 3/4 of respondents in the 2014 CBS survey also told pollsters that they believe the wealthy have more of a chance to influence public policy than other Americans, and more than 80% of Republicans in another recent survey said that special interest lobbyists and campaign contributors have more influence over office holders than their constituents. So our democracy is very sick right now, and I'm not going to argue here that Citizens United is the sole cause of all of this, but I think it is a factor. And I think it is once again something that the court did not anticipate. So you'll notice what I'm not arguing. I am not arguing that we need to get money out of politics, as many of my fellow travelers on the sort of political left do, because I think that's unrealistic. Politics costs money. I agree with Ilya that it's about where the money comes from, and I think Citizens United has skewed that. I'm not arguing that money is outcome determinative. If you look at the Clinton-Trump race, I get it. Money does not always win you the election. Again, though, I think we tend to obsess with the presidency, and we tend to ignore down-ballot races where overwhelming amounts of money can swing the difference much more often than at the presidential level. Finally, because of Citizens United, I'm not arguing that everyone in government is now corrupt and terrible, and actually, this is one of the things I hate most about this election cycle, is this constant denigration of government and public service. I don't think that. In fact, my real beef with Citizens United and with Buckley is that I think that there ought to be other reasons that the government can regulate money in politics. I don't think quid pro quo corruption should be the only reason. However, I do think that the level of at least undue influence and sort of wheeling and dealing that Citizens United has enabled, and I think that the court should be cognizant of that. I'm going to wrap it up here because I think I've gone over my time a little bit. But, Malcolm talked about these as empirical questions and really value judgments, and I kind of agree with this. This is tough questions. I'm not going to deny that, like, what you do about Stephen Colbert and Jon Stewart, and how you work those are hard questions. And I think that, the reality, though, at the same time, is that campaign finance regulation is a feature of virtually every other advanced democracy in the world. So who should decide whether we will be the outlier and have no effective campaign finance regulation? And my view is that Citizens United is exhibit A of why when the court takes an overly aggressive thing and butts into these issues, it tends to get it wrong. Most of the negative consequences of Citizens United are not things the court anticipated. And you contrast it, interestingly, in Citizens United with their almost passive approach to other democratic problems, like partisan redistricting, discriminatory voter cases. The court has been historically very, very, very passive and then incredibly aggressive when it comes to money in politics. So, what I would really like to see is more balance. I think courts do have a role to play, and I think that these are tough questions. And I agree with Ilya, in fact, that the current situation, the current regime is not sustainable. Whether campaign spending is, quote, a graveyard for good intentions, may be true. I just don't think it's for 9 unelected lawyers, most of whom are over the age of 65, to decide. I think it should be you and me who decide that through the democratic process. And that is my basic view of Citizens United.
think we're at the fun part. Not that that was not fun. I think that it's going to get more fun. So here's how this next part is going to work.
By the way, for the record, nothing against Dan, nothing against you or any of you, but I don't want him and his friends getting together to tell me how much political speech.
Oh, good, we'll run the pass a good line.
So here's how this is going to work. So I'm going to ask you questions, and I'm going to stop talking, and hopefully some of you will ask questions. But we're going to give each of these guys 2 minutes to come up and sort of present their perspective on these questions.
Trump.
Yeah.
Trump.
So who's the bad hombre?
So my first question, and I'm not going to throw softballs. I guess for half of you it will be a softball each time. But for the other half, I hope it won't be. So my first question, I'll give you a break, let you sit down for a second. Mr. Schapiro, it seemed like this essential point of contention between the two of you had to do with dark money and whether it's sort of, happy Midwesterners contributing $30 and pooling their money, or if it's sort of dark corporations pouring millions of dollars and nobody knows where it's coming from. So my question, to simplify it, is don't voters, don't the 5 people in this audience have a right to know where the money in politics is coming from? And if they don't, why don't they? So I'd like you to,
Let's be clear, the push for disclosure
Just to read
is a push to chill speech. It's not a push for more voter information. So the voters know that the treasurer of such and such a 501c4 organization is John Q. Smith, rather than not knowing that. What does that do? Or it knows that 5 steps down the line, if you follow the corporate path of a particular dollar out of a larger bundle of dollars, as it goes through various National Chamber of Commerce, State Chamber of Commerce, City Chamber of Commerce, widget manufacturers of that state, and it's all pooled and recombined and whatnot, and eventually that dollar, maybe way back when, is traced back to mom and pop widget shop. That does nothing for the voter. Okay? There can be such a thing as voter confusion from too much information. And moreover, all of this is nonsense to begin with, because the money's not dark. You heard it yourself. It's mining companies, it's charter school advocacy groups, it's energy companies, it's power companies, the Koch brothers, right? Apparently we know who the villains are, so how are they dark? And you can actually look at who the villains are, not even just, kind of ephemerally know that it's a regulation against, mining regulation, well that's by a mining company. But like the Americans for Apple Pie PAC, probably a Delaware corporation. You can go online and look at the Delaware registration, see who their treasurer is, see who their president is, see who a lot of their contributors are. Unless they're 501c4s, I agree there probably shouldn't be tax-deductible thing. I mean, the tax code has a lot of problems, and one of them is these so-called social welfare organizations. I mean, that's kind of bizarre. But anyway, and the same thing relatedly, by the way, for shareholders. If there's a problem with companies acting against their bottom line interest, what companies are supposed to be doing is acting for their shareholders. If they're doing something to harm their own corporate interests, that's when directors should be booted. And if our securities rules aren't strong enough to allow shareholders to know that and to boot directors or officers who are acting against the corporation's interests, then sure, maybe that needs to be fixed. But that has nothing to do with political regulation.
So, first of all, I'm just going to come back to the original reason that we bring up dark money, which is that the court
It sounds scary.
the court
Halloween coming up, right?
Yeah.
Anyone going dressed as dark money? $1 bill just spray painted gray or something?
That was kind of fun.
I'll be here all night.
Okay, yeah. Well, we both
You will be.
It's fun. Snowed in. So a couple different things going on. First of all, I just would return again to the thing that the court in Citizens United was like, oh, everything will be transparent. This will be great. We will have transparent democracy, and they were wrong. They interfered in a very, very, very difficult area of regulation, and they got it wrong. They did not predict accurately how our political system would respond, shockingly, because they know nothing about it. Instead, they waded into this. But to your specific points, Ilya and I actually probably agree on something, believe it or not, which is that I'm not...
Are you a Caps fan as well?
I don't know what that is. Oh, okay. I am not actually a huge fan of small dollar disclosure. I would probably, in many instances, raise disclosure thresholds, because I agree that in some respects, knowing that someone gets $25 or that someone's the treasurer of the campaign, I'm not really sure what that does for people. Now, again, I just bring up my personal experience here as a guy married to a guy who had a big stake in gay marriage. If I knew that someone was rabidly opposed to gay marriage and they'd given money to basically negate my family, I might not want to have them over for dinner. And, I guess I'm not sure that I understand the emotional injury there. Justice Scalia said, these things take civic courage. You want to give money to an anti-gay marriage thing, well, maybe, the gay couple next door want to invite you over for dinner. But that being said, on balance, probably would say that small dollar disclosure is not worth it. But we're not talking about small dollar disclosure. The examples that I gave you, of mining companies and the like, were all uncovered through investigative journalism. Millions and millions of dollars were spent to uncover those examples. So, we cannot have a system where the only measure of accountability is whether a media corporation, or actually in the Utah case, the state legislature can devote millions of dollars to finding out who is behind these ads. And I think at least at a higher level, transparency is common sense and we should have it.
All right, so one more question for me and then we'll open it up to the audience. So this one, we'll start with you. So you said that democracy is sick. I think that a lot of people would say that democracy is healthier than ever. And where do we have to look to decide that democracy is healthier than ever? The presidential race, right? So two of the biggest candidates, Donald Trump as the Republican nominee and Bernie Sanders is the main challenger of the Democratic Party. Doesn't that tell us that, the big money spenders aren't determining that, that Jeb Bush gets to be the nominee? Doesn't it tell us that democracy is healthier?
Think about those two candidates, I think I agree that our democracy is sick.
Should I come up to the, I'm just going to stay here. Let me know if you can't hear me. I would say our democracy is sick for a couple of reasons. One of which is obviously the tenor of this presidential campaign. And frankly, on both sides, the overwhelming populist rage that we have seen. And I think that is partly a money in politics story. And I think it is partly, and Ilya and I are going to really disagree on this, I think it's partly that the court has sort of deprived the American people of their sovereignty on this, as well as a number of other issues. And people feel powerless. And it's interesting because on some of those issues lean left, Obamacare, but I think some of these issues, some of those issues lean right, Obamacare, and some of these issues lean left, money in politics. I do think, and again, I also think, Trump and Clinton, that is what you see in the headlines, but that is not all that our democracy is made up of. Our democracy is an incredibly complex organism. And when we just focus on the presidential race, I think you lose a lot of what's really at stake in this debate. There have always been a ton of money in presidential campaigns. There always will be a ton of money in presidential campaigns. They're huge billion-dollar endeavors. Not arguing with that. But I think that at other levels, particularly, there has been a pernicious effect that I worry about.
I don't know about our democracy. I know our republic is sick. Checks and balances, enumerated powers, constitutional structural protections for liberty. Empowering government and limiting it, as the Constitution sets out. And this isn't an overnight thing. This has been happening for decades as the Supreme Court has allowed constitutional law to diverge ever more from the Constitution. If you Google how John Roberts begat Donald Trump, you'll get one story about this. That's about the NFIB case, the Obamacare case, and how judicial restraint, judges not judging, not having the courage of their convictions, leads to a loss of respect in institutions and therefore the rise of populism rather than faith in the legitimacy of our constitutional system. I think Citizens United has played that role largely because it's been demagogued and misunderstood. So that often perception is reality. And so I do think that it has contributed to the populist burn it all down sort of sentiment. But that's not because of actual legal.
So now we'd like to open it up to any audience members that have questions. So if you have a question, just raise your hand and stand up, say maybe your name.